Floyd B. McKissick Jr., a commissioner with the North Carolina Utilities Commission. With me this afternoon are Chair Karen N. Camerite and Commissioners Jeffrey A. Hughes, William M. Brawley, Tommy Tucker, and Stephen J. Levitas. I now call for hearing in dockets number E-2 sub 1370 and E-7 sub 1325 in the matter of Duke Energy Carolinas LLC and Duke Energy Progress LLC, who shall hereinafter be referred to collectively at times as Duke, joint petition for issuance of storm recovery financing orders, hereinafter referred to as time as the financing orders petition. Before we proceed further, and as is required by the State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any commissioner has a known conflict of interest with respect to this docket. Let the record reflect that no such conflicts were identified. On February 3rd, 2025, Duke filed the financing orders petition along with the pre-filed direct testimony and exhibits of Duke witnesses Thomas J. Heath Jr., Vincent A. Simano Jr., LaWanda M. Jickett, Nicholas G. Spiros, and Jacqueline H. Moore. The financing orders petition seeks the Commission's authorization to securitize storm recovery costs incurred as a result of Hurricanes Helene, Debbie, Zeta, Ian, and Winter Storm Izzy. The public staff, which represents the using consumer public, has been made a party to this proceeding in accordance with North Carolina General Statute 62-15, subsection D. The Commission has further permitted the intervention of the Carolina Industrial Group for Fair Utility Rates, CIGFR, and the Carolina Utility Customers Association, KUCA. On February 11, 2025, Duke filed an agreement and stipulation of settlement with the public staff, which primarily impacted the related storm cost prudency review proceedings, docket numbers E-7 sub 1321 and E-2 sub 1362, which contains recommended assumptions to be used in the cost-benefit analysis in this proceeding. Duke further filed the settlement testimony of Kendall C. Bowman and Laura A. Bateman. On February 12, 2025, the parties filed an amended agreement and stipulation of settlement, which was amended to add CIGFR and KUCA as signatories to the agreement. The public staff also filed the joint settlement testimony of Michelle Boswell, Daryl Brown, Darius Copefield, and Feng Zhang. On February 17, 2025, the Commission issued an order scheduling hearing, establishing procedural and filing requirements, which scheduled a hearing for the purpose of receiving expert witness testimony on the financing orders petition to occur at 1 p.m. today, April 21st, 2025. On February 25th, 2025, Duke filed the supplemental direct testimony and exhibits of its expert witnesses Jickett, Heath, and Moore. On March 26, 2025, Duke filed a second supplemental direct testimony and exhibits for witness Jickett. On April 1st, 2025, the public staff filed the joint testimony of witnesses Michael Botaro, Michael Newman, and Chafin Snyder, and the joint testimony of Darius Copefield, Yamada Maeda, and Feng Zhang. On February 11, 2025, Duke filed the rebuttal testimony of witnesses Heath, Spiros, and Jiggets. On April 15, 2025, Duke filed the public staff filed an agreement and stipulation of settlement, which is comprehensive in nature and resolves all contested issues between Duke and the public staff in this proceeding. On April 17, 2025, the parties filed an amended agreement and stipulation of settlement, which was amended to add CIGFR and KUCA as signatories to the agreement. Also on April 17, 2025, the Commission issued an order directing the stipulating parties to proffer settlement support witnesses at today's expert witness hearing. That brings us to today. I now call upon counsel for the parties to introduce themselves for purposes of the record, beginning with the applicant.
Good afternoon, Presiding Chair McKissick, Chair Kemmerite, and Commissioners. My name is Kathleen Richard. I'm appearing on behalf of DEC and DEP. I'm joined today by Kamal Robinson, an attorney with the companies, as well as Kristen Athens, an attorney with the law firm of McGuire Woods.
Good afternoon, Presiding Chair McKissick, William Creek, C. Creek with public staff on behalf of the UC Public.
Are there any preliminary matters which we need to address at this time?
Presiding Chair, I would also like to introduce colleagues Jennifer Herron and Ann Keyworth, also staff attorneys with the public staff.
Yes, one more.
Good afternoon, Presiding Commissioner and members of the Commission. My name is Mariana McMurray, and I'm with the law firm of Ward & Smith, PA. I'm appearing this afternoon on behalf of SIGFR 2, SIGFR 3, and CUCA. Thank you.
Thank you. Are there any preliminary matters to address at this time?
Yes, Presiding Chair McKissick, we have a few preliminary matters to bring up. First, at this time, we ask that the company's joint petition for financing orders filed on February 3rd, 2025 be entered into the record and then copied into the record at the appropriate time. Second, we ask that the agreement and stipulation of settlement by and between public staff, Duke Energy Carolinas LLC and Duke Energy Progress LLC, originally filed on February 11th, 2025 and amended on February 12th, 2025 to add SIGFR 2, SIGFR 3, and CUCA as stipulating parties be entered into the record and then copied into the record at the appropriate time. We also ask that the company's settlement supporting testimony filed on February 11th, 2025 be entered into the record as if given orally from the stand. We further ask that the agreement and stipulation of settlement by and between public staff, Duke Energy Carolinas LLC and Duke Energy Progress LLC, originally filed on April 15, 2025 and amended on April 17, 2025 to add SIGFR 2, SIGFR 3, and CUCA as stipulating parties be entered into the record and then copied into the record at the appropriate time. We further ask that Ms. Jiggett's direct supplemental direct and corrected supplemental direct testimony, as well as her testimony summary, be entered into the record as if given orally from the stand, and that her direct supplemental direct and corrected supplemental direct exhibits be pre-marked for identification. I would also ask that the direct testimony, supplemental direct testimony, and testimony summary of Ms. Moore be entered into the record as if given orally from the stand, and that her direct and supplemental direct exhibits be pre-marked for identification. Additionally, I would ask that Mr. Sparrow's direct testimony and testimony summary be entered into the record as if given orally from the stand, and his direct exhibits be pre-marked for identification. Further, I would also ask that Ms. Jiggett's and Mr. Sparrow's rebuttal testimony and rebuttal testimony summary be entered into the record as if given orally from the stand. And finally, Presiding Chair McKissick, I would ask that the exhibits of Ms. Jiggett's, Mr. Sparrow's, and Ms. Moore be entered into the record.
Okay. Very good. Without objection.
I apologize. I do have one additional.
I thought there might be some additional ones here. I have direct testimony of Samato as well as Mr. Heath.
Yes.
And a few others.
So I would ask that Mr. Heath's direct supplemental direct and rebuttal testimonies, as well as his testimony summaries, be entered into the record as if given orally from the stand, and that his direct and supplemental direct exhibits be pre-marked for identification. Further, I would ask that Mr. Cimino's direct testimony and direct testimony summary be entered into the record as if given orally from the stand, and that his 4 direct exhibits be pre-marked for identification. And at this time, I would move Mr. Heath's and Mr. Cimino's 4 direct exhibits into the record.
Without objection, I will admit the following, and I'll repeat those to make sure we have everything covered, okay? DEC and DEP's joint petition for financing orders consisting of 21 pages and 3 exhibits filed on February 3rd, 2025. Agreement and stipulation of settlement of prudency review proceeding and assumptions to be used in cost benefit analysis in financing order proceedings consisting of 11 pages, 2 exhibits, and supporting work papers filed on February 11th, 2025. An amended agreement and stipulation of settlement on prudency review proceedings and assumptions to be used in cost-benefit analysis and financing order proceeding consisting of 12 pages, 2 exhibits, and supporting work papers filed on February 12, 2025. An agreement and stipulation of settlement consisting of 11 pages filed on April 15, 2025. An amended agreement and stipulation of settlement consisting of 12 pages filed on April 17, 2025. The direct testimony and exhibits of Vincent Seminaro consisting of 54 pages, 4 exhibits filed on February 3rd, 2025. A summary of the direct testimony of Vincent Seminaro Jr. consisting of 2 pages filed on April 16th, 2025 in sub-A dockets. The direct testimony exhibits of Thomas J. Heath Jr. consisting of 38 pages and 2 exhibits filed on February 3rd, 2025. The supplemental testimony of Thomas J. Heath Jr. consisting of 4 pages and 1 exhibit filed on February 25th, 2025. Rebuttal testimony of Thomas J. Heath Jr. consisting of 21 pages filed on April 11th, 2025. Summary of direct, supplemental, direct, and rebuttal testimony of Thomas J. Heath Jr. consisting of 2 pages filed on April 16th, 2025 in sub-A dockets. Direct testimony of LaWanda Jiggets consisting of 23 pages, 7 DEC exhibits, 7 DEP exhibits filed on February 3rd, 2025. Supplemental testimony of LaWanda Jiggets consisting of 9 pages, 7 DEC exhibits, 7 DEP exhibits filed on February 25th, 2025. The second supplemental testimony of LaWanda Jiggets consisting of 6 pages, 4 DEC exhibits, 4 DEP exhibits filed on March 26, 2025. Summary of the direct, supplemental, direct, and corrected supplemental direct testimonies of LaWanda M. Jiggets consisting of 2 pages filed on April 16, 2025 in sub-A dockets. The testimony of Jacqueline H. Moore consisting of 12 pages, 2 exhibits filed on February 3rd, 2025. The supplemental testimony of Jacqueline A. Moore consisting of 3 pages, 2 exhibits filed on February 3rd, 2025. The summary of direct and supplemental direct testimonies of Jacqueline H. Moore consisting of 2 pages filed on April 16, 2025 in sub-A dockets. Direct testimony exhibits of Nicholas G. Spiros consisting of 17 pages, 2 exhibits filed on February 3rd, 2025. Summary of the direct testimony of Nicholas J. Spiros consisting of 2 pages filed on April 16, 2025 in sub-A dockets. Rebuttal testimony of LaWanda Jiggets and Nicholas J. Spiros consisting of 22 pages filed on April 11, 2025. Summary of the joint rebuttal testimony of LaWanda M. Jiggets and Nicholas J. Spiros consisting of 2 pages filed on April 16, 2025 in sub-A dockets. Excuse me. And of course, from the prudency review proceedings, and I'm referring to E7 sub 1321 and E2 sub 1362, there was settlement testimony of Kendall C. Bowman and Laura A. Bateman consisting of 8 pages filed on February 11th, 2025. And the joint settlement testimony of LaWanda M. Jiggets, Melissa M. Colbert, and Brent C. Gupton, consisting of 11 pages and 4 exhibits from February 11th, 2025. Without any objections, we will admit those at this time. Mr. Zeke.
Yes, good afternoon, Presiding Commissioner McKissick, William Creech again with the public staff. We'd like to admit 2 sets of testimony and then summaries, and so I'll go through those right now, if you may, please.
Yes, go right ahead.
So first, we would like to enter the joint direct testimony of public staff accounting panel, which is witnesses Cofield, Maida, and Zhang, dated April 1st, 2021, consisting of 26 pages and 3 appendices. And we would like to respectfully request the commission's permission to also enter testimony, corrected testimony filed today by those same witnesses, also comprised, today being April 21st, comprised from those same witnesses, comprised of 26 pages and 3 appendices, copies of which we have here with us today and will distribute with the commission's permission. We'd also like to enter, if we may please, the April 1st, 2025 joint direct testimony of the Public Staff Finance panel, being Hilltop Consultancy's testimony, witnesses Bartolotta, Newman, and Snyder. That's comprised of 94 pages and 2 exhibits. And so that's the testimony we would like to enter into the record. And then their summaries, which were filed on April 16th, 2025. We'd also like to enter those into the record. Those were filed in docket numbers E2 sub 1370A and E7 sub 1325A. Those are the summaries of public staff witnesses Bartolotta, Newman, and Snyder, and separately the summary of public staff witnesses Cofield, Maida, and Zhang.
Okay. And I will review those according to the notations which I have here. The first would be the joint direct testimony of Darius Cofield, Hamada Maida, and Feng Zhang, consisting of 26 pages and 3 appendices filed on April 1st, 2025. You also mentioned the corrected testimony of those parties consisting of 26 pages. How many appendices were there? Do you see?
3 appendices.
3 appendices, which was filed today. Is that correct?
Yes, sir. It was a very, very small typo on page 16. Instead of the word EC, it's DEC.
Got it. Thank you for clarification of the record.
Filed in abundance of caution, and our apologies for that.
Not a problem whatsoever. I think it's good to clarify things for purposes of the record. The next would be the joint direct testimony of Michael Percotta, Michael Newman, and Chapin Snyder, consisting of 94 pages and 2 exhibits filed on April 1st, 2025, followed by the public staff witness summaries for Percotta, Newman, and Snyder of Hilltop Securities, Inc., consisting of 3 pages, filed on April 16th, 2025, in sub-8 dockets. And of course, lastly, public staff witness summary of Cofield, Maida, Zhang, consisting of 3 pages, filed on April 16th, 2025, in sub-8 dockets. I gathered there was also information from the prudency review proceeding as well.
Yes, sir. And I was going to get to that now, if I may, please.
Sure, go right ahead.
In the earlier docket, the prudency review docket, those are docket numbers E7 sub 1362 and E7 sub 1321. The public staff filed the joint settlement testimony of Michelle Boswell, Darrell Brown, Darius Cofield, Hamath Maida, and Feng Zhang on February 11th, 2025. And that was comprised of seven pages and one appendix.
Okay, so we would also be adding to that the joint settlement testimony of Michelle Boswell, Darrell Brown, Darius Cofield, Hamada Maida, Feng Zhang, filed in the prudency review proceeding, that being E7 sub 1321 and E2 sub 1362, consisting of 7 pages and 1 appendix. I think you indicated a filing date of February 11th. I see a filing date of February 12th.
My sincere apologies. I had February 11th, but I will go with your date.
Well, let the record reflect that we are agreeing that that is the same document, notwithstanding whether it was filed on February 11th or February 12th.
Yes, sir.
Are there any objections?
No objections.
Without objections, it's all admitted into the record at this time.
Thank you.
Now, of course, we indicated with an order that was entered at the end of last week that we wanted to receive testimony, direct testimony today to support the settlement. So I will look to the applicant at this time to call forth any witnesses that you have that you would like to present. And we're going to try to direct our attention simply to testimony supporting the settlement and stipulation which have been entered into.
Thank you, Presiding Chair. Duke Energy calls the panel of Ms. Jiggets, Ms. Moore, and Mr. Sparrows to the stand.
Okay. If you would, go and put your left hand on the Bible and raise your right hand. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right. Beginning with Ms. Jiggets, would you please state your name and business address for the record?
My name is LaWanda M. Jiggets. My business address is 410 South Wilmington Street, Raleigh, North Carolina, 27601.
And by whom are you employed and in what capacity?
I am a Rates and Regulatory Strategy Director employed by Duke Energy Carolinas, testifying on behalf of Duke Energy Carolinas and Duke Energy Progress.
Are you testifying in support of the settlement today?
Yes, I am.
All right. Turning to you, Ms. Moore, would you please state your full name and business address for the record?
My name is Jacqueline Moore, and my business address is 411 Fayetteville Street, Raleigh, North Carolina.
By whom are you employed and in what capacity?
I'm a Rates and Regulatory Strategy Manager for Duke Energy Business Services, LLC. DEBS is a service company subsidiary of Duke Energy Corporation that provides services to Duke Energy and its subsidiaries, including Duke Energy Carolinas, LLC, and Duke Energy Progress, LLC. Testifying on behalf of DEC and DEP.
Thank you. And are you testifying in support of the settlement today?
Yes.
All right. And now turning to you, Mr. Sparrows, would you please state your full name and business address for the record?
Yes, my name is Nicholas G. Spiros, Director of Accounting for Duke Energy Business Services. And my address is 525 South Tryon Street, Charlotte, North Carolina.
All right. And are you testifying in support of the settlement today?
Yes.
Great. At this time, the panel is now available for questions from the commission.
All right. And I will address this question to you generally. The settlement that's before us today is, of course, the result of give and take and compromise. And there are a number of matters and contentions that Duke took from the outset that where positions have changed based upon the document that's before us. And likewise, public staff has its position on some of those same issues. Would you like to address any differences and nuances between your original testimony and the outcome that's reflected in the settlement and stipulation that's before us at this time?
I think generally the company is supportive of the settlement agreement. There are some minor differences that are articulated in that settlement agreement from the original testimony, specifically mine.
Would you like to address that more specifically?
Sure, absolutely. I think in the settlement agreement, we talk about upfront financing costs, and we talked about how to give upfront financing costs back to customers. In my testimony, we were recommending that we would give it back to customers in the first true-up. So it would be part of that first true-up period. Whereas in the settlement agreement, we've decided to set it up in a regulatory asset or liability, give it back to customers to be audited in the next base rate case and given back at that appropriate time.
And I believe that's set forth in section 2 of the stipulation agreement.
1 second, just to double check.
I think beginning on page 3.
That's correct, yes.
And in terms of the way that that issue has been resolved, if we were to go back to the original securitization that was done, here in North Carolina. I believe the position that Duke has taken is that you wanted to do it the way it was done as it related to that particular securitization transaction. Were there advantages or disadvantages, or why was your position that at that time, and why is it reflected differently in the stipulation? If there perhaps illumination you can provide.
Sure, absolutely. Again, we fully support the settlement agreement that was arranged, but in my testimony, we offered to give it back in the first true-up form. That's returning any potential overcollection from customers to customers in a quicker fashion than putting in a regulatory liability and waiting for a base rate proceeding. However, we're supportive of the settlement agreement.
And are there advantages to doing the way that it is reflected in the settlement agreement?
How do you mean?
Well, does it allow for certain flexibility or opportunities to provide some type of operational efficiencies by doing it the way it's specified in the settlement agreement as opposed to doing it the way it's been handled traditionally?
Traditionally, it's been handled through the true-up form. It's maybe a little bit more expedient to do it that way as opposed to hanging it up in a regulatory liability, booking a carrying costs return on that, and then providing a benefit back to customers in a future case. So it's more of a timing thing than anything, I would say.
Okay. And is there any additional testimony that either Ms. Gicketts or Ms. Moore would like to provide relating to the settlement agreement and what's reflected there versus testimony which you provided originally?
I'll speak a little bit to the servicing and administrative fees portion of the settlement. I believe what we've agreed to here is consistent with what we did in the first securitization proceeding from Presiding Chair McKissick, and it will allow for some administrative efficiency because we'll be doing the same process that we agreed to in that filing.
Okay. And let me ask you this, Ms. Giggets, have you done any analysis, the break-even point, in terms of the yield that the bonds could pay and still provide quantifiable benefits to customers?
I have not done that type of analysis to see like what's the amount that the bond rate could be where we would potentially no longer show savings. I have not done an analysis to see how far they could go, but I do believe witness Heath will be before you later could provide some information on how changes in the bond rate would impact what we're seeing in terms of benefits to customers.
All right. And Ms. Moore, is there anything that you'd like to point out in terms of the settlement versus your original testimony?
There's not. I'm supportive of the settlement agreement.
Very good. Let me do this. Let me see if there are other questions from commissioners. Chair Camerite.
Yes, so under section 2, paragraph 1, which deals with upfront financing costs, that states that once the upfront financing costs are known, if the actual upfront financing costs are in excess of the estimated cost, but a regulatory asset will be established. Is that the difference between what the agreement that's been reached here? Was there a difference between Duke's position and the public staff's position in that regard?
Not that I'm aware of, no.
No, Commissioner, there wasn't a difference between how we would handle regulatory assets. The initial position, there was a difference in how we would handle regulatory liabilities with respect to upfront fees.
And we are required, the commission is required to make a finding about quantifiable benefits to the customers from bond securitization as compared to the costs that have been incurred absent the issuance of the storm recovery bonds. Can you just walk the commission through the quantifiable benefits that would be provided to customers pursuant to this settlement?
Yes, I can. So what we're required to demonstrate, as you summarized, Chair Camerite, is that by issuing the storm securitization bonds, we're going to save customers money compared to what they would pay through base rates in accordance with the general rate case proceeding. And I lay out those calculations in exhibits 5, 6, and 7 of my testimony for DEC and DEP. The specific quantifiable benefits are going to be shown at the bottom of Exhibit 5. And with my corrected testimony, I am showing that we will save customers 16.1% for DEC and 12.1% for DEP by issuing bonds to recover the to recover storm costs for the amounts in question.
And the other finding that the commission is required to make, and this is included in testimony, but I'd like to have it provided by settlement testimony today, is that we have to determine that the structuring and pricing of the storm recovery bonds are reasonably expected to result in the lowest storm recovery costs consistent with market conditions or the time that the storm recovery bonds are priced in the financing market. Can you walk the commission through the evidence that you provided to demonstrate that finding will be met based upon the settlement?
I think questions about the structuring and pricing of the bonds are better addressed to witness Heath and Semino when they're before you.
Reserve that question for when they are here to testify. Is there any other information that the panel would like to provide to demonstrate that the settlement is in the best interest of the class?
I would again just like to point the commission to Exhibit 5 of my testimony for both companies where we are showing that which is consistent with the statute, that we are saving customers money by issuing the bonds to recover the storm costs in question.
Thank you. That's all the questions I have.
Other questions from other commissioners? Yes, Commissioner Tucker.
Thank you. Folks, thank you for being here today. We appreciate you coming forward with your testimony. I'm not a lawyer, so for my own edification, help me understand in a stipulation and agreement. Would you consider the stipulations of the settlement open-ended?
I would consider the terms of the settlement to be applicable to what we're asking for in this proceeding. So I think they're governing how we would treat specific costs that are we're going to incur as a result of moving forward with the bond securitization process. That is my understanding. I'm not an attorney either, but I believe the terms of the settlement are specific to this transaction that's before the commission at this time.
Thank you for that statement. I guess where I'm coming from is I see words like next base rate proceeding. I hear words like true up. I hear parties reserve the right to argue their points. I also see in stipulating parties not being bound, and that neither the stipulation nor any of the items shall be admissible in any court or commission except so far as such court or commission is addressing litigation arising out of the implementation of the terms of the approval of this stipulation. Yeah, I know you don't know all the costs, that's what you're stating.
Mm-hmm.
So that's what makes it look to me like it's open-ended, because everybody has the flexibility to come back, true up. And when I hear true up, I hear rate base, and I hear in this instance, the rate base having some sort of impact because you don't know what the numbers are. I'm not holding to the numbers. I understand where we are today, all of us, with the stipulations and the cost continuing to come in from this unbelievable storm. But help me understand what I'm going to see as a commissioner down the road, if at all, without knowing the numbers. Maybe you can't answer that, and I'm okay with that. I just see those terms, and not being a lawyer and not, words have meaning. And, it just seems like there could be some initial rate impact from the storm ongoing for another year or two.
Okay. Yes. So I will try to answer that for you as best I can, Commissioner. So you're correct. As we sit here today, there are estimates in the storm recovery costs for Helene and Debbie. that we have said we will true up in a future rate case proceeding. There are also costs associated with moving forward with the storm recovery bond process, where we have included our best estimates, and we will also need to true those amounts up at a future point in the case. What we have agreed to specifically in this portion of the settlement is for those things like the upfront financing costs, for the ongoing financing costs, and the servicing and administrative fees. We've said we've included our best estimates. To the extent we are off, allow us to record a regulatory asset or regulatory liability on our books, subject to a WAC return, and we will decide, we'll bring those amounts before this commission for you all to decide how we recover it from customers or provide it back to customers at that time. That is consistent with what we did in the 21 case as well. So it's just allowing us to set aside that amount. It could be a case where we need to collect more. It could be a case where we need to return the money to customers. But the mechanism we're asking for today allow us to be able to do that. You would have the opportunity to tell us or give your input on how we do that when we come before you in the next case. With respect to the cost for Helene and Debbie, we would want to do the same thing to the extent that we are above or below when we have the final numbers for Helene and all the dust settles and all the money spent, to be able to come before this commission and say, this is where we ended up. We either need to collect more money from customers or give money back. And at that time, we would propose the best mechanism to give that money back to customers.
Okay, so in this agreement, the number was roughly, correct me if I'm wrong, 1.1 billion. Is that where we were?
I think
One-
after the settled numbers, you're right about $1 billion. Right
Oh,
about
okay,
600 million for one, 500 for the other.
So with that $1 billion that's going to come from the securitization of the bonds, by the way, they are a fixed interest cost, right? Or do I need to ask somebody else that question?
The bonds that will be issued will have a fixed rates associated.
Right, fixed rate. I thought so. So it's safe, I'm just trying to understand that with the $1 billion that we're appropriating now, I think Ms. Bowman answered the question, she'd rather go ahead and get that money now and move through with the settlement, as opposed to having to go to court and carry it on the books. So this will offset some of the expense you've already had. Can I glean from this that it's safe to say that there's probably going to be an increase in the rate base when the true up comes?
I can't know until the actuals are finalized. We really will not know that until we have all the actuals in for the storm and then can do the calculations to compare what we got from the bonds from what we actually needed. And that will determine the amounts that we ask for in a future rate case proceeding.
So are you sharing with me that you are saying that the $1 billion or whatever the number really is that we're appropriating here is more than what you need to manage Helene, Debbie, and all this together?
I don't know. I won't know until the numbers are finalized. Like we included our best estimate of what the Helene and Debbie costs were. And we've agreed upon that number with the public staff, but I will not know what the final number is until all the actuals are in for Helene and Debbie.
Yes, ma'am. Ms. Jig, I probably don't think you're a gambler, but I'll gamble with you that it's going to be more than what the $1 billion is here, but I understand you can't tell me because you don't have the numbers. When will all those numbers finally be in?
I
You
believe
project.
from witness Colbert's testimony, who testified before phase
Right.
one, that it takes a year plus to kind of get all the numbers finalized. So we're not even to the year mark for Helene. And then that's just for normal restoration. There's also some rebuild that's happening as well. So we're still, I think, a few months away from being able to have final numbers.
So am I to think that it's going to be in 27 when the merger's taking place?
I think it would, if based on witness Colbert's testimony, I think it would be before 27 that we would possibly know that, those final numbers, but I'm not sure exactly if it will be before the bonds are issued in 25. I think it will be after the bonds are issued and sometime in 26 would be my best guess. But again, witness Colbert's testimony is probably
Right.
the best place to look.
Okay, well, thank you so much for answering that. I know the questions were open-ended and you don't know. I just, well, I can't predict the future, neither can you. Thank you so much.
You're welcome.
Ms. Jiggets, let me ask you one thing. Could you turn to page 4 of the stipulation and settlement?
Yes, sir.
All right, you see the top caption that talks about ongoing financing costs.
Yes.
And this provision here kind of addresses a lot of the ongoing costs that be involved with the transaction. Is that correct? The securitization?
Yes, I believe it does.
All right. And of course, I believe what it says here, the stipulating parties agree to the ongoing financing costs of each company's respective special purpose entity created for the purposes of the storm securitization transaction shall be recovered from storm recovery charges, taking into account the company's proposed true-up mechanism. So is this an accurate representation of the way that would be adjusted through the storm recovery charges?
I'm actually going to defer this to Witness Barrows because he's the expert.
Go
on
right
this
ahead.
particular part of the
Yeah,
calculation.
for ongoing financing costs, this part in the settlement agreement is essentially codifying, for lack of better words, what we're already doing from our 21 deal.
Right.
So it's just putting it in writing and saying we will continue to do that in this deal as well.
And of course, it goes on a little further to talk about the way the companies will provide the public staff with detailed invoices and supporting documentation, if applicable, and narrative explanation for ongoing financing charges on a monthly basis, 15 days after the end of a previous month. Is that correct?
That is correct, yes.
And then I believe the next paragraph, there's language here that provides the public staff with an opportunity to audit these ongoing financing costs, including auditing through possible additional document requests for mathematical or clerical errors or charges incurred as a result of gross negligence, recklessness, or willful misconduct by either the companies or the SPE, and the public staff shall have 45 days to conduct such an audit. And of course, they can request additional supporting documentation. Now, this is not currently applicable. This is something that's new as it relates to this particular securitization.
That's correct.
Okay. I guess I want to clarify that for purposes of the record as it relates to these ongoing expenses. Chair Kemmer, did you have further questions?
Just following up on both Commissioner Tucker's and Commissioner McKissick's questions. I think Commissioner Tucker mentioned that some of these issues might be open-ended, but under the upfront financing cost provision of the settlement agreement, if the financing costs, if the actual, and I guess this is for Ms. Jiggets, if the actual financing costs end up being in excess of the best estimate of the financing costs, the public staff would have the opportunity to do an investigation and make a recommendation to the commission about whether those actual financing costs are actual, prudent, and reasonable, and bring that position to the commission. Is that right?
What we agreed upon in settlement is exactly what we did in the last securitization, where if upfront financing costs are over collected, we're going to defer those to a regulatory liability and bring those before the commission in our next rate case proceeding. So yes, the public staff would have an opportunity to look at how that amount was determined and in connection with the future rate case.
So there's a specific process for dealing with potentially any discrepancy between best estimate of costs, financing costs, and the actual financing costs.
Correct. We would basically track the differences between the estimates and the actuals, record the appropriate regulatory asset or liability, and bring that amount forward for the commission in the next rate case proceeding, and that would be subject to audit by the public staff as well as any other interveners at that time.
And the same for the best estimate of storm recovery costs for Hurricanes Debbie and Helene versus the actual storm recovery costs. Is that correct?
Correct. The public staff and interveners would have an opportunity to review any adjustments we are seeking with respect to estimate versus actual storm recovery costs in our future rate case proceeding as well.
And make whatever argument that they think is appropriate based upon the information that they receive about those actual costs.
Yes, it is our understanding that the reasonableness and prudency review of those actual costs would happen in connection with the next rate case.
Okay. So they would be considering in their investigation whether the costs are correct, whether they're reasonable, and whether they're prudent.
That is my understanding.
Okay, thank you. That's all the questions I have.
Are there any further questions from commissioners? Not seeing any. Are there any questions on commissioners' questions? I understand that there's been a waiver of cross-examination.
Thank you, Presiding Chair. I just have a few. Mr. Sparrows, this is in reference to Presiding Chair's question on the estimated upfront financing costs and the potential benefits or advantages of the settlement position. Would you agree, one advantage, in addition to the timing, as you mentioned, is it provides the public staff a longer runway to audit the costs?
I would agree with that.
Would you also agree the customers would receive the interest on any over-recovered cost in the next general rate case?
That is correct, yes.
And is this treatment consistent with the 2021 proceeding?
Yes, it is.
That's all the questions I have.
Thank you. I think this panel can be released. We'll receive any other witnesses who would like to proffer.
At this time, the company calls Mr. Thomas J. Heath Jr. and Mr. Vincent A. Semino to the stand.
Would you put your left hand on the Bible and raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you.
Beginning with Mr. Heath, would you please state your name and business address for the record?
Yes, my name is Thomas J. Heath Jr. My business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services, which is a service company affiliate of Duke Energy Progress and Duke Energy Carolinas, as a corporate finance director.
And are you here testifying in support of the settlement today?
Yes, I am.
Thank you. Now turning to Mr. Semino, would you please state your full name and business address for the record?
My name is Vincent A. Semino Jr. My business address is 200 VC Street in New York, 10281. Sorry.
By whom are you employed and in what capacity?
I'm a managing director with RBC Capital Markets in the Securitization Finance Group.
And in addition to providing your expertise here from a banking standpoint and managing director at RBC Capital Markets, are you also here to support the settlement to the extent you are able?
I am.
Thank you.
Thank you both for being here this afternoon. And of course, Mr. Heath, you've been around this, covering this turf back when the original securitization was done, and I think you handle all the securitizations that Duke does company-wide, so you're very steeped with knowledge and expertise as it relates to these transactions.
That's correct.
All right. Now, during the prudency review hearing, involving dockets E-2 sub 1362 and E-7 sub 1321, you testified that Bloomberg had moved to exclude storm bonds from the corporate index and that the SEC had barred issuers from making disclosures that the bonds are not asset-backed securities. Am I remembering your testimony correctly?
You are remembering that correctly, yes.
All right. Since the date of that hearing, I think it was February 13th, 25, have there been any new developments in the bond market, either by positions the SEC has taken or other regulatory bodies that might impact how you can market and sell the bonds you think you're likely to, what the bonds that you will be selling and how it might impact your marketing plans? So how will your marketing plans be different if anything has changed, or particularly as it relates to things that have occurred recently, or perhaps even things that have occurred since the original securitization that you handled here in North Carolina?
I would say our marketing plan, in terms of how we approach potential investors, the number of investors we go to, those sorts of things are not impacted in any way by those developments that you mentioned from Bloomberg or from the SEC. Our intention for these bonds is to speak to as many investors who will listen to us make our sales pitch for these bonds. So we want to have as many potential investors focused on the transaction and placing orders in the transactions, because that allows us to have pricing tension in the book, is what we would call it. So the more interest we have, so it was mentioned earlier, we've got about $1 billion worth of bonds to sell here across these two transactions, both for DEC and DEP. So the more orders we have, if we have people placing orders for $3 or $4 billion in our order book, that gives us more leverage to drive in pricing and get a lower interest rate, which turns into lower customer charges. Right. So our marketing efforts will be unimpacted by those developments at Bloomberg or the SEC.
Let me ask you this. I've read that there are fewer buyers for the bonds, and that they're considered kind of asset-backed securities as opposed to corporate bonds, that there are certain investor groups that will not likely find these bonds appealing, these storm recovery bonds, in terms of investments that they would make. Could you speak to that issue?
Sure. I would say my experience is I don't believe that to be the case. Investors understand. So I'll back up to our 2021 transaction, and probably even back up to 2016 when we did a transaction in Florida around a retired nuclear facility, early retired nuclear facility there. And probably even back up further than that, just give a broad context here. So this product, this kind of storm recovery bond, or more generally called a utility cost recovery bond, this structure was kind of put in place in the mid-1990s, at the time that certain states, particularly California and Texas, were deregulating their generation businesses, right? So utilities in those states had stranded assets. And so this securitization product, this utility cost recovery bond structure, was put in place to basically give a tool for those utilities to recover those stranded assets. Okay. And they were used quite frequently in the late 1990s and maybe into the early parts of 2000. And then once those kind of transition costs were recovered and financed, there was really a dearth of activity in this space. So we came to market in 2016 with a transaction in Florida. There had been very little in the way of utility cost recovery bonds issued in the span of several years. And so we felt at that time that it was very important to distinguish these types of bonds from what you could call as traditional asset-backed securities. So things like portfolios of credit card accounts, or portfolios of car or auto loans, portfolios of mortgages, and those sorts of things. Because those things have risk in them, even though they're AAA rated, they have risk in them that are not present in these utility cost recovery bonds. So if a bank finances a portfolio of auto loans or credit card loans, and then we get into a recession or other economic hardships, or people just for whatever reason quit paying their auto loan or their unsecured credit card loan, that is cash that never becomes available to service that debt. If you think about this product that we're talking about here, we have this true-up mechanism that we've talked about a little bit here already this afternoon. It's talked about quite extensively in our testimony. What that does is mitigates that risk of non-payment for bondholders, makes this a stronger credit feature. And so if there are shortfalls in collections, we do an interim true-up or a semi-annual true-up, and we reset the charge upward, if that's the scenario, to the rest of the customers who are still on the system, and they make up that shortfall. So unlike those credit card loans where somebody defaults and there's never cash coming into the structure to repay that debt, we don't have that here. So our credit is superior to those things, I believe, right? So we had to make the case in 2016, and again to some extent in 2021, that this was not a traditional asset-backed product, right? And we did that through three key things. And the first of those was how we structured the SPE, the special purpose entity, what index these bonds were placed in at Bloomberg. So Bloomberg maintains corporate bond indices and it maintains asset-backed security indices. We preferred corporate to make these look more like corporate bonds. And then the third feature was in the Bloomberg financial database, where investors and issuers and other interested parties look up publicly outstanding debt and equity securities. You can tag a security in one of three ways, principally, as a municipal security, which these are not, right? These would be some things issued by the state of North Carolina or by Wake County or by Mecklenburg County. Those would be found under the municipal ticker. And then there's the mortgage ticker, which is where traditional ABS securities have been found. Asset-backed securities have been found in Bloomberg. And then there's the corporate ticker, which is where everything else is found. So all of Duke Energy's and its subsidiaries' publicly outstanding debt, including first mortgage bonds of DEC and DEP, can be found in the Bloomberg system by someone typing in DUK, which is the Duke ticker symbol, and hitting this corporate key on Bloomberg, on a Bloomberg keyboard. And that would bring up all outstanding public debt securities of Duke Energy Corp and its affiliates. Okay. If these bonds were placed on the municipal ticker or on the mortgage ticker, someone who's looking for Duke's outstanding debt would not find those by that simple search of DUK corporate. Okay. So those three things were important for us in 2016 and again in 2021 to make these look more like corporate bonds because of that infrequent level and amount of issuances since the late 1990s and the early 2000s. Okay, so we were trying to make the distinction that these are not traditional ABS, and so they don't have the risk that are involved in someone who wants to buy a portfolio of auto loans or a portfolio of credit card loans or mortgages. Okay. That default risk I mentioned earlier is more reduced. So we made those arguments in 2016. We structured the SPE in both 2016 in Florida and 2021 and here in North Carolina as what's known as a series trust. So a lot of these issuances they're all been issued with SPEs, special purpose entities, but how you set up that SPE. So a lot of these were issued where it was effectively a single purpose entity. So all this entity was ever going to do was issue this one set of debt securities and it could do nothing else. Couldn't issue additional debt. Okay? We used something called a series trust in 2016 and in 2021. And that allowed that entity to issue not only those bonds that were issued in 2021 in North Carolina, but they could have been the issuer for these bonds that we're talking about here issuing in 2025. By being a series trust, that excluded these bonds from meeting one definition, a particular definition of what an asset-backed security is for the purposes of Securities and Exchange Commission rules and regulations. And so we could make a disclosure, because we were using a series trust, we could make a disclosure in our registration statements in 2016, and then again in 2021, that we did not meet the definition of an asset-backed issuer, and that the bonds being issued did not meet the definition of asset-backed securities. Again, to distinguish them from auto loans, credit card loans. In 2024, early 2024, the SEC issued some new disclosure guidance. So something called a commission, or it's like a C&DI, or Content and Disclosure Initiatives, I think is what the acronym stands for. Where the SEC effectively came out and said, you know, these, regardless of how you're setting up this series trust, we believe these are truly asset-backed securities. And you should know it's inappropriate for issuers to make the disclosure that they are not ABS issuers and that these are not asset-backed securities. So that happened in 2024. So so we can't make that disclosure we made in 2021 anymore. The other development that's happened in the last couple of years since we did our 2021 transaction is that at Bloomberg, again, they used to allow these types of bonds. They used to allow the issuer, so the SPE or the sponsor, Duke Energy in this case, to request the index they wanted to be in, corporate bond index, ABS index. On our 2016 transaction and our 2021 transaction for the tranches that were large enough, and that large enough definition was $300 million or more, we could place those in the corporate bond index, and we did that in 2021. So Bloomberg reached out to market participants, both issuers, investors, other parties during 2022, and asked them for their opinion on how these bonds should be classified from an index perspective going forward. And we, at that time, sent an email to Bloomberg saying that we thought these would be more appropriate to be in the corporate index, and we laid out reasons why. Bloomberg, and I think it was early 2023, put out their guidance as a result of that consultation, that survey. And they said, going forward, these utility cost recovery bonds, regardless of whether they use series trust or some other thing, are going into our ABS index. And they actually went and reclassed our tranches from 2021 and 2016 in Florida from the corporate index to the ABS index. Okay. The corporate ticker I talked about in the Bloomberg financial database is still can be used, and we intend to use that ticker. So those developments, though, I think what your ultimate question is what impact, if any, do those developments have on this type of product, right? And I would say that I believe that impact is minimal, if any. And the fact and that reason is because I talked about that situation in 2016. We did a deal in Florida. Had not been any of these types of utility cost recovery bonds done for a number of years. We believed it was very important to the success of that transaction to distinguish it from those traditional ABS products. And so we did those three things that I talked about: corporate ticker, corporate index, series trust, and made the disclosure that these were not ABS securities. We moved through time from 2016 to 2021. There's been some additional issuances, still not a lot, though. So we felt it was important to make those same arguments in 2021, take those same three positions. If we look at market activity from 2021, after our deal in 2021, so 2022, 2023, and throughout 2024, there's been a lot more activity in this utility cost recovery bond space, both in the number of transactions and in the issuance amount. And our experience from a small deal that we did, relatively small deal, that we did in South Carolina in 2024, about $177 million, investors understand this product now. They understand the credit, and that the fact that there is now consistency at Bloomberg about what index these bonds are going to be in and what disclosures are going to likely be in registration statements, that brings stability and consistency to the landscape of these bonds, which investors appreciate, right? All this volatility that we've seen over the last 2 to 3 weeks have been about uncertainty with how tariffs are going to play out in this country, right? Uncertainty leads to volatility, leads generally to widening of pricing, more expensive interest rates, right? So consistency in the landscape provides benefits. And so the fact that investors, again, know that what disclosures they're likely going to see, what index this is going into, that provides benefits. And now this allows investors to look at specifics of each transaction and what is the credit quality behind this transaction. So it gives them an opportunity to be more focused on the regulatory landscape. So how strong is the statute and how constructive and strong is the financing order? And both of those in North Carolina are very strong. The statute, the enabling statute, the storm recovery statute is very strong. The financing order that we used in 2021, what we're proposing here in 2025, is very strong, and that would give investors comfort that their security interest is protected. The other factor is, excuse me. Is the strength of the service territory. So how strong is the service territory that is paying the charge that's going to repay the principal on these bonds and the outstanding interest on these bonds, right? And DEC and DEP service territory both are incredibly strong, right? Over 1 million customers each. I mean, there's been deals done in the last couple of years, even including our South Carolina transaction, that only had a couple 100,000 customers repaying the charge. And those bonds priced extremely well and delivered significant savings for customers in those states. But we're talking about here 2 territories that have over 1 million customers each. And the robustness of the true-up mechanism and the other factors that are embedded in the financing order provide investors comfort that this is a strong credit. And that's what's going to be more successful to the outcome and the success of a transaction sponsored by Duke Energy here in North Carolina, is the strength of the regulatory construct and the robustness of the customer base. Those are going to be far more important factors than what index is this in, how is this SPE set up, and is the registration statement making an assertion that these aren't asset-backed securities, right? Our experience from 2021, 2024 in South Carolina, I've never heard an investor say they cannot or will not buy these bonds because they're classified in a certain manner versus another.
Well, thank you for that very thorough and extensive explanation. And I would agree with your assessment. These are clearly distinguishable from traditional asset-backed securities, and of course, you have the storm recovery charges, which are irrevocable, which, you know, it's going to help anybody who is an investor in these bonds.
Yep.
Notwithstanding that fact, they're still not considered corporate bonds, and therefore there would be a higher interest charge, theoretically, or higher costs associated with them as opposed to what it would be if they were treated as corporate bonds. Would you agree with that assessment if you were looking at it, what I will say generically in terms of the market? I understand what you've identified in terms of the nuances related to Duke, the service territory, and all the other credit matrix that might come to bear.
So I would say that even though there's been a significant uptick in the amount of bonds issued, both the number of transactions and the amount issued over the last several years, there's still concerns about liquidity, and liquidity meaning how much of these bonds are out there, and how many potential buyers are out there. So the majority of the bonds that we sold in 2021, and I expect the vast majority that we're going to sell here in 2025, are going to be bought by folks who are going to intend to hold those bonds to maturity. And so they're not looking to resell those bonds, but they want the liquidity there in the event that they need to, right? These are bonds that are going to have maturities out to 20 years. So who knows what happens in the next 20 years. So investor appetites and positions could change, and they may want to be out of these positions, and they want the liquidity to be able to sell out if they sell those bonds if they need to at some point in the future. So there's, even with a lot of more frequent activity and a more volume that's been done over the last several years, there still is not the liquidity in this space that would be there in things like AAA rated corporate. There are not a whole lot of AAA rated corporates to start with, right? There's only a handful of companies. So we're talking about Johnson & Johnson, we're talking about Apple, Microsoft. If you look at the amount of outstanding debt that those entities alone, any one of those entities have outstanding, it is a multiple of what is outstanding in total across the utility cost recovery bond space. And so there's liquidity in those AAA rated corporate names that just is not there in these types of bonds, even with the increased activity that we've seen in them over the last couple of years. So that's one factor, right? There's plenty of secondary market liquidity for Microsoft and Apple and Johnson & Johnson, right? And there's actual, and most importantly, there's actual trading that happens in those names in the secondary market. Secondary market meaning when we initially take a deal to market and we price it, that's called the new issuance market. Any sales of the buyer sells of those securities after they're initially priced and issued be secondary market activity. Think of it like new construction on a house, right? That's new issue markets. Reselling a house between two counterparties, that's a secondary market. And so there is actual secondary market activity for Microsoft and Apple and Johnson & Johnson. There's very little secondary market activity in utility cost recovery bond space because people buy this and intend to hold it to maturity. All right, so that's one thing that's going to be that disconnect between pricing is that there's a value that is placed on liquidity. And when there's deep liquidity there, things are going to price better than when there's lacking of or less liquidity. So just think about it from a two cost recovery bonds. And we saw this a couple of months ago in New York. There was a deal issued by two separate subsidiaries of I'm blanking on the ultimate sponsor name, but it was Rochester Gas and Electric, and then Public Service New Jersey, I think it was. The one deal was a lot bigger than the other. They priced within about a week of each other. The New Jersey transaction was like 4 or 5 times as big as the smaller Rochester deal. And the Rochester deal priced about 10 basis points, I think it was, higher or wider than the New Jersey deal. Most likely because just that liquidity, right? Smaller deal, less liquidity, going to cost probably a little bit more. All right, and if we think about how we then price this, how these price against other AAA ABS things, because we need investors from both the traditional ABS space to buy our short dated bonds, and we need people with crossover from the corporate market to buy the longer dated bonds, right? So we talked about that pricing comp to AAA rated corporates. Another factor I'd add there before I move to ABS is that these bonds are amortizing over time. In the corporate bond space, most bonds are bullet maturity. So the first mortgage bonds that we issue at DEP and DEC, we issue $750 million due in 10 years. We just pay interest on that for 10 years, and then we repay the principal in 10 years. These bonds, these storm recovery bonds, are going to repay principal during the 20-year period. So that's a different thing that could lead to pricing differences as well. We shift over to comparing these to traditional ABS products like credit card portfolios, auto loan portfolios. They price most of these high quality ones with robust service territories are pricing right around, and Mr. Cimino can correct me if I'm wrong on this, we're pricing right around those auto loan and credit card portfolios. The thing I'd point out there is, again, a liquidity issue. Those credit card portfolios, those auto loan portfolios are issued by repeat issuers. So think about a Bank of America that's bringing a credit card portfolio. They're doing, if not multiple deals a year, probably deals at least every year. And so there's liquidity just in that Bank of America name, even though it's a credit card product, that isn't there in a Duke Energy storm bond, right? Because we're coming to market with $1 billion for 2 utilities. They might be doing, hundreds of millions of dollars of auto loans or credit card portfolios at least annually, but probably maybe multiple times a year. So those can be pricing differences as well, or can lead to pricing differences as well.
Now, do you plan to structure this transaction as the last securitization was done here in North Carolina with the Series Trust? Establishing it in a similar way?
So no, we could use the series trust, but even if we did, the SEC has said we cannot make the disclosure that we made in 2021 that these are not asset-backed securities and that the issuer is not an ABS issuer. So there's really no benefit of using the series trust because we can't make the disclosure that we made in the past.
So that would preclude us or preclude Duke from doing it that way based upon the classification of
It precludes us from making that disclosure.
Right.
We could use the series trust.
but it would not be benefit.
Don't see a real, right. Don't really see a benefit in doing that.
And in terms of quantifiable benefits, because this is all what it gets down to in the bottom line, would there not be greater quantifiable benefits if these were treated as traditional corporate bonds? And have you done any analysis as to what the difference might be in terms of transaction?
I've not done any sort of analysis as kind of I alluded to throughout that that discussion that we just had. I really don't think there is a difference. So these are not, so I would say we think about corporate bonds, again, the bullet maturities, right, backed by the underlying credit rating of that entity, whether that be Duke Energy Progress issuing first mortgage bonds or Microsoft issuing AAA rated 10-year bullet maturity bonds. These bonds are different because they amortize, and there's not really anything in the traditional corporate space that amortizes. Amortizing products are in the traditional ABS space, right? So we can position this as best as we can under the current things to distinguish it from auto loans and credit card loans and those sorts of things. But it has features that look more like ABS, at least a structured product.
Right.
And as you're aware, I think we talked about this in phase one. I think you're definitely aware about this from our 2021 bond advisory team discussions. The marketing effort for these bonds is much different than the marketing effort for DEC or DEP's first mortgage bonds, right? We prepare in advance for an issuance for first mortgage bonds, but the market doesn't know about that transaction until we come in one day, talk with our underwriting lineup, and decide whether we think this is a constructive day to be in the market. And if it is, and we go forward, we make an announcement that morning that Duke Energy Progress, for instance, is issuing $1 billion or $750 million of first mortgage bonds, and the investors who are going to buy those bonds look at that announcement across the ticker, right, of whatever else is out that day, and they decide whether to buy those first mortgage bonds or they buy something else. And they place their orders, and we price up a transaction by 2 or 3 in the afternoon, and we're done, right? Intraday announcement to pricing. These bonds price over a period of multiple days, and there's generally pre-marketing in advance of that official announcement. So folks know these deals are coming. And then when they get announced, there is a multi-day kind of book building process. And so that multi-day looking process, or that multi-day process, looks a lot more like what happens in the ABS space than it does in the corporate space. And the reason behind that, needing that multi-day process, is that investors need to understand the financing order, they need to understand the statute, they need to understand the true-up mechanism, all these things that make these bonds work. They need to understand that. They need to go to their internal committees and get sign-off to actually place orders before they can put orders in. They don't need any of that in the first mortgage bond space.
Very good. And I think you've done an excellent job in distinguishing the niche that you're trying to get these bonds into so that they're most attractive and appealing to investors. Let me switch gears a little bit. And under the stipulation, and we talked about it with the prior panel that was here, under section 2, paragraphs 1 and 2, they concern what will be done with over and under recovery of upfront financing charges. Um, Can you share your experience of the magnitude of these amounts from prior securitizations? And how close the actual numbers are typically to what's been provided in terms of a final estimate?
Sure, I would say, and I'm trying to remember back to 2021, like a specific number. I know the number, it was a couple $100,000 on several $1 million worth of financing fees. And so I would point you to my supplemental or my corrected supplemental testimony. And there is an exhibit there, Heath Exhibit 1.
Okay,
And we scheduled out our estimate of what upfront financing cost would be for these transactions. So we come to a number that's just short of $5.8 million for DEC and a little bit over $5.1 million for DEP. And you can see the types of fees that are in there. And I can walk you through these and kind of like where, why I feel these are good estimates. And then as we go through time, how these become more firm estimates, right? We're looking at a transaction in October, November timeframe, kind of our general idea at this point. And so as we go through time, all this continues to get refined. And we're proposing a bond advisory team, much like we had in 2021. And so we'll share updates to these numbers with the bond advisory team. And we'll all understand where we're headed with these costs. And so by the time we get to issuance day, we would expect these numbers to be fairly well locked in. Only a handful of these items that may not be finalized at that date. And so that's where the difference comes from. So when we think about underwriting fees, we're going to agree to a dollar or an amount of underwriting fees with the underwriter group. Right now, this is based on 40 basis points, so 0.4% of the amount of debt that we issue. And that's standard if we paid in 2021, what we paid in 2024 in South Carolina. It's what other deals have paid more recently. So that number is going to be set, right? Whatever we issue, 0.4% of that's going to be the underwriting fee. The rating agency fees, we're going to have a contract with the rating agencies that's going to lock in the amount that we're going to pay them for, but to rate these bonds, right? And that's generally going to be also a percentage of the issuance amount. So we're going to have very clear line of sight into that expense. Public staff consultant and commission consultant or financial advisor. These numbers at this point when we develop these are estimates, but as we go through time and we start having bond advisory team discussions, I'm sure the public staff will be willing to give us their input on what a better number looks like based on their contract with Hilltop, right? If the commission hires a consultant, we would assume at some point you're going to tell us what that fee is. We can bake it into here, right? Our structuring advisor fee, we have a contract with RBC where we're paying them $400,000. And actually, I'm seeing an issue here. So we're paying them $400,000 in total. And so this should be $200,000 per entity, not $400,000 per entity.
right.
So we have that contract today. We know we're going to pay them for that. Accounting fees is an estimate today, but it's based on what we paid in South Carolina and what we paid in North Carolina in 2021 for Deloitte to do their what's called agreed upon procedures work, right? We're gonna have a bunch of numbers in our registration statement, and it's going to be statistics on our accounts receivable, our number of customers, how quickly we collect cash from customers, how much of our billings have we charged off over time. And they're going to have to go and do some diligence on those numbers. And so there's a fee to, unfortunately, there's a fee to that. SPE setup fees, I think is that next one. SEC fees is the next one, the $95,000 and the $75,000. The SEC requires us to pay them to register bonds with them. And we can go out to the SEC website and see what percentage that is of the bond issuance amount. And so same, very much like the underwriter fees or the rating agency fees, we'll have clear line of sight into that. Marketing and miscellaneous, we have to pay someone to host a secure site for investors to log into and review our presentation that we will talk to them about. So there's those fees. We'll have an invoice for that. We'll know what that fee is by the time we get to pricing day. Right. So we'll adjust that if it needs to be. Same thing with the trustee, with all the other items on here. So really there's most of this is going to be well known. By the time we get to the issuance date, there'll be very little of it that we don't have an invoice for. And then we'll use our best estimates. Okay. Most of that'll be known numbers, but there'll be some difference. So when you think about this 5.8 and the 5.1, I would say there's maybe a couple $100,000, if that's not going to be known by the time we price the bonds and put together our issuance advice letter.
Thank you for providing that clarity. I think that's important for the record. And you would assume that at this point in time, these are pretty good estimates, but there will obviously be movement.
Mhm.
And I know previously, the bond advisory team typically met about once a week on telephone calls
Correct.
to receive updates, all the way up to the time of issuance.
Mhm.
And would you assume that that would still be a relative frequency that it might be done on related to this securitization?
I think 1 week was every week in 2021 was definitely the right cadence for an initial transaction.
Yeah.
We're open to talk with commission representatives who may be on the bond advisor team, with the public staff, with Hilltop, to figure out what is the right cadence, particularly when we are in the earlier stages of the transaction.
Sure.
So if we all believe that weekly is where we should be, then we'll agree to weekly. If we think that there are times where maybe there's a little bit less going on and we meet every other week, that could be workable as well. But it will be regular and frequent discussions.
And in terms of the quantifiable benefits and in terms of savings by going with securitization, could you go into what Duke has determined to be the projected savings from the securitization transaction for DEC and DEP?
Yep. So those numbers are in witness Jiggett's testimony, but my recollection is the savings for DEC, again, at the time we filed our supplemental testimony, was about 16% for DEC and about 12% for DEP. Those were based on interest rates and market conditions that existed. I think it was around February 12th. So right around the time of our phase 1 hearing, I think, right? So we had the settlement in phase 1, and we went back and redid our structures and all of our exhibits and testimony for those dollars that had been agreed to in phase 1. And so those are a little old at this point, right? And there's been a lot of volatility over the last several weeks. But those are the numbers that we had at that time, 16 and 12. We will do throughout the bond advisory team process, though. We will provide updates multiple times, I'm sure, throughout the bond advisory of what the snapshot of quantifiable benefits looks like at different points throughout the process, almost kind of as a deliverable in advance of key decision points, right? So before we file a registration statement, we'll update quantifiable benefits, and we'll show that to the bond advisory team and talk about it before we start getting too far into the rating agency process, probably before we meet with the agencies for the first time and make our lengthy presentation to them that I'm sure you remember.
I do.
We'll have that refresh of those numbers, right? Before we get into doing any kind of pre-marketing with investors, we'll take another do it. And those are just a couple that come to my mind right here. But if there's just a request that, hey, there's been a lot of volatility, let's take a look at this again, we'll accommodate that.
And of course, this transaction, I should say, the securitization is based upon the known storm damages today, but that can be supplemented as we approach the date of issuance.
So I think our
Or may
attorneys
change, maybe.
clarify. So we're securitizing estimates that were signed off on in phase 1. And so the number that that I'm looking at here included that estimate for Helene and Debbie with our financing costs, that 5.8 and 5.1 that we talked about, of $589 million for DEC and $466 million for DEP. The underlying storm cost in those numbers, those estimates won't change. What could change is if we are able to be in the market with the transaction before October 31. So those numbers were estimates with carrying charges through October 31st. If we can work very expeditiously as a bond advisory team and get through the SEC process with minimal comments and work quickly through the rating agency process and be in a position to issue bonds in early to mid-October, that number comes down because the carrying charges are lower, right? If we happen to extend beyond October 31st, that number is going to go up a little bit because of those carrying charges and the adjustment of any transaction cost or the financing cost, right? But the estimates that were approved in phase one are the numbers, the core of what will be financed here. And as the prior panel was talking about, once those numbers are finalized and they're audited by the public staff or reviewed by the public staff, and if they're to the extent that those actual costs are different from those estimates, those will be dealt with in a future rate proceeding. Just that delta, right? Because 589 and 466 will have been financed through the storm bonds. Does that make sense?
Yes, thank you for that clarification. Because when I read about the change, I wasn't sure if they were potentially looking at changes in the actual total of the bond recovery numbers as opposed to the way you just articulated it. And the costs that would be incurred in terms of carrying costs beyond November 1, what are they estimated to be, either on a monthly or weekly basis? Do you recall?
I do not recall offhand. I think that may actually be in our petition. It's in the,
I recall reading it. I don't recall the number.
It's in the petition or it's in Jiggett's, witness Jiggett's testimony.
If I may, Commissioner, I
Yes.
believe it is in Ms. Jiggett's testimony and should be around 3 to 4 million.
What I wasn't, that was the number I had in mind, but I wasn't clear if that was a total number for both DEC and DEP, or if it was one or the other. Here we go. I am looking at page 14. And there's a sentence, this begins, so this is page 14 of witness Jiggett's direct testimony. And it is $4 million per month for DEC, $3 million per month for DEP. For a full month,
Full
for a
month, yeah, yeah.
Right.
Thank you. I think it's important to just have it articulated in the record. And I guess, Mrs. Simonano, the only question I had for you, and I think Mr. Heath has kind of addressed it some already, assuming these bonds, and of course, Mr. Heath has indicated they will be marketed as ABS securities, can you provide any context on the additional yield that this would cost relative to marketing them as corporate bonds? I mean, and when I'm saying that, how many basis points, for example, 10 basis points, 20 basis points, how would that impact it if you know, or could, and when I say no, give me your reasonable intuitive judgment based upon your knowledge of the market as it relates to these types of securities.
Yes, Presiding Chair McKissick, I'll do my best. I thought Mr. Heath did a great job of describing the process, but to the question you asked, it's a difficult one, and I'm not sure I can quantify it in basis points as you asked, because I've never seen that.
Or any other method that you could
Well,
use as a
I
basis
can
of
tell you our
comparison.
approach.
Okay.
And I think Mr. Heath touched on it, and we're not selected as an underwriter. We hope to be, but let's assume we were. What I've seen at RBC, this is a sector that's very important to RBC. And as such, we've dedicated quite a bit of resources. I think we're kind of uniquely structured in the sense that we blend together the investment grade team and the team I work on, the asset-backed team. So the team that's been working on this transaction with the Duke team to put together the preliminary bond structure has been a collaboration amongst 3 or 4 teams at RBC, including the investment grade debt team. So we work closely hand in hand with those. When and if we are selected as an underwriter, we would also use both syndicate desks, not to mention the municipal desk. These wouldn't be municipal securities, but we would still use the desk. We want to cast our net as widely as we can. So we would actually use every nook and cranny, every desk that we had, the investment grade, the asset-backed, and municipal desks to broadcast, in the word that Mr. Heath used, to make this well-known, or as well-known as we can. Getting to a point you had asked earlier about investors, I would characterize it as the utility securitization sector has been maturing. I think Mr. Heath described it really well. Even though the first securitization was in 1997, I think, there was sort of a very sporadic, you might call it cadence or a lack thereof during the 2010 to 2021. That hurts liquidity. As he spoke to, investors want to see new issuance. They want to see where the new bonds are pricing. That could, as he said, most investors tend to hold them. So you want to use the new issuance as a proxy. And without regular new issuance, you don't have that. So it makes it very difficult because of the liquidity issue that Mr. Heath referred to between the two markets, or between our sector, the utility securitization sector, and the investment grade debt market, because those are very regular. They're regular cadence. There's a strong secondary market in those bonds that adds to getting very good investor reception to your deal. So getting back to how we'd approach this, we would cast our net as wide as we can. So we'd use all those desks. We'd touch on investment grade investors. We'd touch asset-backed investors. We'd touch municipal. I think Mr. Heath made the point earlier, and I would concur. And we have never had an investor. We have worked on Duke's last 3 deals. We work for other utility securitizations. We haven't ever seen an investor come back to us and say, why wasn't this corporate, or why wasn't this ABS? We have seen sort of an agnostic approach, and that's the approach that RBC has by blending our desks and bringing all of those resources to bear on your deal, is because we want to get, as Mr. Heath described, as oversubscribed, that is, as many orders as we can for this $1 billion deal. We'd like 2 or 3 or 4, ideally, because that builds tension, and that allows us to bring rates in.
Thank you. Let me see if there are questions from Chair Cameron.
Just a couple of questions, I think, directed to you, Mr. Heath. So first of all, just a very general question. Does Duke support the agreement and stipulation of settlement? And is Duke requesting that the commission approve the stipulation?
Yes, we are.
And the first page of the stipulation states that the stipulating parties agree that the stipulation serves the public interest. Is that your opinion as well, that the agreement is in the public interest?
Yes, I believe it is.
And then the stipulation also states it's in the public interest because the stipulation will promote efficiency, reduce litigation costs, and achieve a balanced outcome on disputed issues. Are you in agreement that the public interest will be met by those matters?
Yes.
And then in addition, we heard testimony from Ms. Jiggets and then also from you about some benefits to customers and savings of about at the time that the application was submitted, 16.1% for DEC and 12.1% savings for DEP. Is that correct?
Yes.
Okay. And would that also contribute to the stipulation being in the public interest?
I believe it would, yes.
And then one final question that I have, and this is just, I want to make sure that the record is clear for some, I appreciated all of the explanation that you provided, but I'm looking for some really concise information about the benefits or how the structuring, the timing, and the pricing of the storm recovery bonds will provide the lowest possible costs to the customers. And I think that you testified in response to questions from Commissioner McKissick about timing, depending upon when the bonds are issued, the timing of that could provide some benefits and savings to customers. Can you just describe, so that we can have it clear for the record, what Duke is going to do in regard to structuring, pricing, and timing these bonds so that customers will, the charges will be the lowest possible for the customers?
Sure. And so I'll point out that there are two things that we have to certify to at the end of the day. We provide our issuance advice letter. We have to give a certification on two matters that we consider the statutory cost objective. So the first is that there are demonstrable, quantifiable benefits. So that's the first prong, right? If we don't have benefits, we don't go forward with a transaction, right? And that could be, and here we just talked about 16% and 12%, right? Those numbers will likely be different to some extent. It could be more, could be less. Hopefully they're more by the time we get to October, right? But if we have quantifiable benefits, then we move forward. And then the next level, which is a more stringent requirement, is lowest storm recovery charges consistent with market conditions. And so our issuance advice letter will lay out all the things that we've done from the time that we received the financing order from this commission that led us up to the pricing of those bonds. And that's going to be, it's going to be documenting a lot of conversations that have been had with the bond advisory team, right? We talked about these factors. We met this many times. We discussed all significant matters or all matters of structuring, marketing, and pricing these bonds. We talked to X amount of investors. We made lengthy and robust disclosure in our registration statement. We worked through answering all the questions that came up from rating agencies and those sorts of things. But we will document in that letter all those things that we did to achieve that pricing outcome. And we'll certify as to whether we believe that pricing outcome results in the lowest storm recovery charges consistent with market conditions at the time those bonds are priced. And so we believe that given the volatility we see today, we don't know how long that volatility persists, that we need to be in a position to work quickly as a bond advisory team after receipt of this financing order to do everything that's going to result in that being able to make that certification. And that is things like selecting the underwriters. That is, what disclosures do we make in the registration statement? When do we get in front of the rating agencies, and how quickly we can respond to comments from the SEC? How quickly can we respond to comments and questions from the rating agencies? And so the more quickly we can navigate each of those things results in us clearing those kind of hurdles, right? The quicker we can clear the SEC comments, the quicker we can clear the rating agency process and be ready to go to market is going to enable us to better make that certification. So if we can trim time off of our calendar that we showed in here and be in a position to be ready to issue bonds in early October, and there's a good window to do that, we should be in a position to do that. That makes sense?
It does. Thank you.
Commissioner Hughes.
Yeah, Mr. Heath, is a question for you, but if you'd like to answer it. And it was actually a question for public staff, but you've been so articulate in the last half hour about the financial implications of this. And I know that's primarily why we're here. I just want to share with you a struggle I'm having and get your perspective on it. You've obviously looked a lot at these numbers and this analysis. At times, we look at the customer base as the customers. We've had a lot of statements up here, and it's in the testimony, saving the customers money, lowest cost to the customers. At times, we're a little bit more precise when we're talking about the customers, and we look at different types of customers. We look at intergenerational equity. And I don't find that nuance is here, and I don't think maybe this is not the place for that kind of nuance. But I can't help but think when I look at the cash flow analysis here, that if we did wear that hat and we think about the customers in 15 years as tomorrow's customers, many of them which don't live in North Carolina now or are my kids, and they're going to be paying the bill, versus the customers today, from an economic and equity hat, are we really saving those customers in 15 years money from the traditional method? And just one other thing, the traditional method in your financial analysis, I see is, and I know this is not necessarily your testimony, but in the financial analysis is traditional method amortizing O&M costs over 15 years. As far as I know, and I could be proven wrong, that isn't really the traditional method from rate making for here or really common utility rate making. It would be to make that a much shorter period. I think in the past we've done typically 5 years. Occasionally we've gone out to 10 years. So I'm just struggling with this whole discussion about traditional versus this new approach. Financial savings versus equity and equity savings. And I just would like to have, for the record, a little bit of discussion about what this entire process is doing for future customers versus current customers, traditional versus securitization. So I know that's a lot, but
Yeah.
go for it.
And yeah, and you're right that I am not the foremost expert on for this question, but what I would say is it is my recollection that storm recovery costs have traditionally been recovered over shorter periods of time in North Carolina. I think my recollection is that those dollars were much lower than what we're talking about here. $1 billion here. We had $1 billion in 2021 from prior storms, right? So I think, if you tried to recover that over 5 years, 3 years, 12 months, I mean, that's a sizable impact, right? And so, securitization is a means to lower that impact and making it more manageable. It does kind of extend it out over what might be a different, or what might be done through base rates. But I think with the dollars that we're looking at, I think it's important that we look at a long-term view of this.
We do a net present value.
It is a net present value number. So these numbers are present value back to today's dollars. And that shows that it gets to that 16 and 12% level of customer savings.
I think one of the thresholds, along with what Mr. Heath just said, is the fact that the securitization accesses capital. We're borrowing money at a AAA level, whereas in the normal or traditional case, you're not. So there's a different cost to that money at each of those rating levels. And I think that's the sort of the crutch of why securitization gets a quantifiable benefit. And I think it gets back to Chair Kimmeray's question about it's a bright line, right? We either have them or we don't. You don't issue, we don't have them.
Well, and I appreciate that, and I'll leave it for that. And I think your first response, which I agree with, is we're definitely saving customers money in the next 4 or 5 years, particularly if we went the traditional approach. Again, we're asked up here to look at customers in a variety of different ways, and I have a little heartburn over the long term, particularly when we're having these storms much more frequently. And yeah, yes, Hugo was, I think, the last big storm that we used to talk about, and that was under 100 million. And now we've had these storms, it seems like much closer together, and the science is telling us they will continue to be much closer together. So I'm just sharing with you some heartburn, but I appreciate all of the effort you're going to make this a good financial deal, and I appreciate all your testimony along those lines. So that's all I have.
Are there any other questions from commissioners? Not seeing any. We'll see if there are any questions on commissioner questions.
Neither CUCA nor SIGFR have any questions for these witnesses.
Okay.
There are questions from public staff.
Just one question. This question is for Mr. Heath. You recall Chair Kimmerai asking you questions about evidence, perhaps in the settlement, to say that the structuring, marketing, and pricing of the bonds should result in lowest price bonds at the time of pricing. Is that correct? Do you recall that question?
Yes,
And you discussed the IAL process, is that right?
I did. Yes.
And just to be clear, the settlement addresses the IAL process as well as the company's proposed financing order. So it is laid out in the proposed financing order and settlement for the commission.
Yes, it is.
Thank you. No further questions.
Thank you. And let me ask the applicant, do you have any other witnesses that you plan to put on this afternoon?
We do not at this time.
Very good. Well, let me thank you both for testifying. We're going to go ahead and why don't we take a 10-minute break? And we will resume at approximately 3 p.m. And public staff will be able to put on its panel. Thank you.
Thank you.
Okay, Mr. Creek, we're gonna recognize you so you can introduce your panel.
Thank you. And I'll defer to my colleague,
Yeah.
Jennifer Harrod, if I may, please.
And let me do one thing for purposes of the record. Commissioner Tucker had a pre-existing commitment that he needed to attend to. So he is requested to be excused from this hearing, but he will read into the record anything that he has missed by not being here present. Are there any objections to that?
No objection from the public staff.
No objection from the companies.
All right, thank you. Now, go ahead. Yes,
No objection from SIGFR or CUCA.
all right. Attorney Harrod?
Thank you, Presiding Commissioner McKissick. The public staff would now call to the stand Darius Cofield, Hemeth Mehta, and Finn Zhang, please.
All right. If you could put your left hand on the Bible and raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
All right, thank you.
Mr. Cofield, would you please state your name, business address, and current position for the record?
Sure. My name is Darius Cofield. My business address is 430 North Salisbury Street, Raleigh, North Carolina, the Dobbs Building. I'm a public utility regulatory analyst for the accountant division of the North Carolina Utilities Public Commission.
And are you here today to testify in support of the settlement that was reached in this matter?
Yes.
Okay, thank you. Mr. Mehta, will you please state your name and your business address and your position for the record?
Sure. My name is Hemant Mehta. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I'm a public utility regulatory analyst with the accounting division of the public staff.
And are you here to testify in support of the amended settlement agreement that was reached among the parties in this matter?
Yes.
Okay. And Ms. Zhang, will you please state your name, business address, and your position for the record?
Sure. My name is Fan Zhang. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I am the public utility regulatory supervisor for the electric section of the public staff accounting division.
And are you here to testify in support of the settlement agreement that was reached among the parties in this proceeding?
Yes, I do.
Okay, thank you. Presiding Commissioner, this panel is now ready for commission questions.
All right. Thank you for being here this afternoon, and I think we'll be able to move your panel on relatively quickly. Obviously, there's a lot of give and take and compromise that goes into a settlement. And of course, as a part of that process, testimony you might have originally provided supporting different issues or was stating certain contentions may or may not be reflected in the settlement agreement that's before us. Are there any distinctions that any of you all would like to make as to what your testimony was originally compared to what the facts are as stated in this amended stipulation settlement agreement?
We support our settlement agreement. So things inside the settlement agreement are give and take. So we take into consideration of all parts.
Either of the other witnesses like to state anything?
No, we support, yeah, I mean, we support the stipulation.
All right. Let me ask this one question. Several of the public staff's recommendations concerning flowback of over recovered amounts involve removing the flowback from the true-up process to a future general rate case. Of course, Duke's rebuttal to these points generally noted that these recommendations run counter to the prior securitization, and in doing so, they were referring to dockets E-2 sub 16, sub 1262, and E-7 sub 1243. Does the public staff have any concerns about how the true-up process worked in the existing securitization that was previously done back in 2021 that caused you to want to potentially, see things handled differently. So I'm just trying to understand how we're moving from what was originally done to, or why your thoughts were that process needed to change.
Well, in our settlement, I guess we wanted to, in our past, in this settlement, we wanted to make sure that when we review the invoices and supporting documentation from the companies, that they provided it to us in a timely manner so that we could do our due diligence on our end and make sure that we recognize and make sure that the costs were prudent and reasonable.
Yep, so let me add on a little bit. So based on, since the first securitization, we have about 3 years review on those semi-annual or interim true-up. Although at the beginning, there has a little bit kind of like required the interim true-up, but I think later we resolved the issue. So now it's more smooth. And then the way they provide the invoice on the monthly base, and then we have the 45 days to review it. I think that is, as listed out in the stipulation, is sufficient for us to review it. And if we have issue with the company and that it cannot be resolved, that we will bring it into the next general rate case for the commission to decide. So overall, I think based on the first securitization, I think the supporting documentation, the true-up, all those things, it works smoothly as far.
So it sounds like the testimony that you're providing supports the provisions under Section 2 of the stipulation settlement agreement in terms of the provisions that are related to there being an opportunity to review the documentations, the details, documents that would substantiate, expenses, and to allow you to potentially audit it if you found it necessary to do so. Is that correct?
Yes, so that's for the ongoing financing costs. So as laid out in the settlement agreement, the ongoing financing costs that have like kind of separate into 2 buckets. The servicing fee and the administrative fee, it will be subject to true up to the actual on the general rate case. And then on the other ongoing financing costs, it will true up in the semi-annual true up. And then that the company agree as in the settlement agreement, they will provide those invoices and supporting documentation on the monthly basis. We have 45 days to review those up to the file.
Okay.
Provided to us.
Thank you. Let me see if there are any further questions. Chair Cameron.
I have a few questions that are similar to what I asked the Duke witnesses. And I believe my first question has already been answered, but again, does the public staff support the stipulation, and is the public staff asking that the commission approve the stipulation?
Yes. Yes.
Okay. And the stipulation states on the first page that the stipulation serves the public interest by promoting efficiency, reducing litigation costs, and achieving a balanced outcome of disputed issues. Does the public staff agree that the stipulation will serve the public interest?
Yes.
Yes.
Public staff agrees.
Okay. And in addition to those matters about serving the public interest, similar to what I asked Duke, Duke witnesses talked about customer benefits of savings of about 16.1% for DEC and 12.1% savings for DEP due to the securitization. Is the public staff in agreement with those customer benefits?
Yes, the public staff is in agreement with the company's analysis. So it is 16% for DEC, that is about $63.8 million. And 12% for the DEP, it is $43.5 million in the net quantifiable benefits.
Okay, thank you. And are there any additional customer benefits that would be provided due to the stipulation allowing the securitization that would benefit the customers that you want to bring to the commission's attention?
as some of these costs are estimates, so as we have, as we go further in the line, like when these costs are finalized, at that time, we might be able to see what benefits this comes up. And as we have discussed in the initial securitization prudency review cost, at that time also, we have highlighted some of the costs, like about $61 million as a result of a change in estimates in the first time, which we did 3 months back. And those are some of the things which, as we review the cost, then we might find some things.
Okay. And then finally, Mr. Heath, I asked him to provide a concise explanation of what Duke will be doing to structure, time, and price the issuance of the storm recovery bonds to provide the lowest cost for customers. Do you have any concerns, or are you in agreement with his testimony about that being a sufficient process to achieve the lowest cost possible, reasonably possible for customers?
We would like to refer that to our consultants, Hilltop consultants, who are going to come next after our panel.
I'm sorry, can you repeat that?
We are going to refer that question to our consultants, who are going to come after us.
Okay, I will reserve that question then. So thank you very much.
Thank you.
Commissioner Hughes?
All right, same question, but much more concise. Hopefully this will help the court reporter. Do I have it right that under this new securitization approach, compared to the traditional approach, that future customers, if you define them, customers 10, 20 years from now, won't actually be saving money, but they'll actually be spending more money than they would under the traditional approach?
So in this traditional approach, first thing is we are calculating the return on a weighted average cost of capital, which will be higher than what we would be doing it in this storm securitization first. The second thing is that in the traditional method of the O&M expenses, it is previously we have done, the commission has approved those costs to be amortized over 10 years. So now here we are doing over 10 to 50, it's about 20 years now. And the other thing is like the cost, the magnitude of the cost in this current securitization are very high compared to which we have done in the past for the strong, like under $100 million or something like that.
Yeah, so we will, as in the first prudency settlement discussion, we will go back to historically looking at the cost and then further evaluate. But this is the second securitization based on the quantifiable benefit analysis is producing the savings to the customer by using the net present value.
Okay. But mathematically, customers that will start service in 10, 11, 12 years, will they be saving money under the securitization approach versus their traditional approach, which from what I understand has generally been 5 years. Occasionally there's been a request for 10 years, but I think that's really rare. So a 5-year period versus this 20-year securitization, mathematically, will they be better off?
This time, actually, the storm cost is a little bit higher than the last one for one of the companies. So historically, the commission have taken into consideration of the 10 years instead of 5 years. So yes, in terms of the long-term benefit, I would say if based on the quantifiable benefit analysis, still, if it's not producing the net benefit, then the company won't pursue the securitization.
I appreciate that. Customers defined from year 10 to 20, will they be better off? Just yes or no. Will they have savings? Yes or no?
It's a difficult.
I'm not holding you responsible for it. It's just the securitization system that we have.
Yeah, it is a kind of a
Maybe,
Tricky, not a, it's,
maybe.
we don't know the correct.
Okay, okay, we'll leave it at that.
At this point of time.
Yeah. And the second question was if that concerns you at all, but I won't ask that question. So,
We don't have concerns at this point of time, but yes.
okay, thank you.
Are there any other questions from commissioners? Yes, Commissioner Levitas.
Would you just explain your preference for handling the over recovery of upfront financing costs through a deferred liability and recovery in a subsequent rate case as opposed to through a more real-time true-up mechanism?
Yes, so, by the statute, the interim, the semi-annual true-up or the interim true-up is the way we allowing us to audit, it's just checking for the mathematical and clerical errors instead of like full audit of the cost. So the public staff believe it will be better to review the cost once we get to the rate case. So it would be better to put it into the regulatory liability account to make sure we take into account for everything.
Great, thank you so much.
It's my understanding Duke is waiving cross-examination, so are there any questions on commissioner questions?
Just a couple, Presiding Commissioner. Let me ask you all if anybody can say concisely, compared to the 2021 financing orders that this commission issued and the proposal or the settlement that all of the parties to this proceeding have reached, can you summarize the changes, if any, between those two agreements with respect to the accounting issues?
Yes, the only change is the capital contribution that capped at the weighted average cost of capital for from the last general rate cases.
Okay, so, and can you say what that is? I don't think you closed out the thought.
So what we say is the return on the capital contribution calculation, that will be the cost to the customer. And currently, the Duke is proposing the interest rate of the longest tranche of the bond. And then the public staff, for our testimony at that time, we don't believe that should be fair to the customer, but we, based on give and take, and we settle on the same as the longest interest, longest tranche of the bond interest rate, but cap it at the weighted average cost of capital from the docket number E-2 sub 1300 and E-7 sub 1276.
Okay, thank you. And there's been some, I think, varying testimony about how we're going to handle it if the upfront servicing charges end up being, the estimated upfront servicing charges end up being greater than what the actuals are. So a situation of an over collection. And is the treatment of that over collection of upfront servicing costs the same as how it was done in the 2021 financing order?
Yes, it's same as the commission issued the order, the same as the settlement as well. The only thing is different in this case is the Duke is proposed differently, slightly different. They want to include it in the first true-up.
Okay, but in settlement, the agreement that was reached was consistent with the 2021 financing orders, correct?
Yes.
Okay, all right. And to Commissioner Hughes's question, let me just ask this. When the public staff is faced with an issue where there are extraordinary costs to be recovered from ratepayers, and those are going to be amortized over a period of time, does the public staff commonly wrestle with the question of whether it would be better to have lower monthly charges, but that will extend over a longer period of time versus higher monthly charges that will only be applied for a more limited period of time? Is that a common problem that the public staff wrestles with?
we do take into consideration and do analysis on that. However, those will be more like a bill analysis than just like to take into the nominal amount of like over a length of a period of time. So the comparison is slightly different.
Anything else for Mr. Maida, Mr. Cofield?
Yeah, and one other thing is that like we have to look at the issue by issue. It is not like it's a generalized one. So depending upon what the circumstances are, that's when we look at like it should be spread across a couple of years or a one-time charge like that.
And in the prudency phase of this proceeding, the public staff at Duke agreed to discuss in a holistic fashion the recovery for storm expenses on a going forward basis. Do you expect intergenerational fairness to be one of the topics of conversation in those discussions?
Yes, we do. And in fact, we are as in the stipulation, we agree to work with the company on the incremental O&M discussion as well. So we will take into consideration of all the storm costs and take it and see where we can land it in different recovery mechanism for the storm securitization costs.
Okay, thank you. I don't have any further questions.
SIGFR and CUCA have no questions for these witnesses. Thank you.
Thank you. Well, I believe this panel can be excused.
Thank you.
Thank you.
Presiding Commissioner McKissick, the public staff would like to call witnesses Newman, Bartolotta, and Snyder of Hilltop Securities on behalf of the public staff, please.
Okay. You could put your left hand on the Bible, raise your right hand. You swear the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon. Mr. Bartolotta, would you please state your name, business address, and current position for the record?
Certainly. Michael G. Bartolotta. I work for Hilltop Securities at 700 Milam Street, Suite 1200, Houston, Texas. I'm Executive Managing Director, Co-Head of Public Finance.
Thank you. And Mr. Newman, would you please state your name, business address, and current position for the record?
Michael Newman. I work for Hilltop Securities at 6100 Fairview, Suite 550, Charlotte, North Carolina, 28210. I'm a Senior Managing Director.
And Mr. Snyder, would you please state your name, business address, and current position for the record?
Sure. My name is Chafin Snyder. I'm a Senior Vice President with Hilltop Securities. My business address is 485 Madison Avenue, Suite 1800, New York, 10022.
And Mr. Bartolotta, has your firm, Hilltop Securities, Inc., been engaged as a consultant to the public staff in this proceeding?
Yes.
Okay. And Mr. Bartolotta, are you here testifying in support of the amended settlement today?
Yes.
And Mr. Newman, are you here testifying in support of the amended settlement today?
Yes.
And Mr. Snyder, are you here testifying in support of the amended settlement today?
Yes.
Thank you. Presiding Commissioner McKissick, the panel is available for commission questions.
Okay, thank you. If you would turn to page 6 of the stipulation and settlement. And I'm referring to the section here near paragraph 11. It says statutory benefits confirmation letter. Okay, looks like you're all there. Of course, this provision states the stipulating parties agree that consistent with the commission's financing orders and docket numbers E2 subs 1362 and E7 sub 1321 in 2021, it is reasonable for the public staff's consultant to file a letter with the commission opining as to whether the structuring, marketing, and pricing of the storm recovery bonds and any storm recovery bond securities achieve the statutory cost objectives. The letter shall state the report of any action or inaction which the public staff consultant believes prevented the transaction from achieving the statutory cost objectives. And it goes on to say, in concluding, that the stipulating parties shall include in their joint proposed financing orders in this proceeding provisions from the Commission's 2021 financing orders supporting such a letter from the public staff consultant, namely findings of fact 48, including paragraph 30C. Now, is this your understanding as to the way this provision will work moving forward? And more importantly, could you be a little more precise as to the reference made to the 2021 financing order, finding of fact 48 and concluding paragraph 30C?
I believe the reference to the 2021 financing order was the provision that provided for the consultant to the public staff to provide a letter to the commission as opposed to a certification. And we have proposed a certification or a letter, and through the process of negotiations and give and take, it was agreed with the company that we would provide a letter to the commission.
So a letter is what is anticipated at this time?
Yes, sir.
All right. And in terms of reviewing all of the documents, the facts and statistics and everything that will be available at that point in time, I assume that you would not have any difficulty in reaching an opinion as to whether the structuring, marketing, and pricing of the storm recovery bonds achieve the statutory cost objectives.
Historically, we have not had a problem rendering that letter or certification. So in the normal course of business, working constructively with the company, the staff, we should be able to send you that letter.
And have you provided similar types of letters or confirmations as it relates to other securitizations that were done by other utilities in the
Yes.
past?
We've given issuance of vice letters and we've given certifications. And most recently, I believe it was in Oklahoma gas utility securitizations.
Okay, very good. And in terms of the overall structure of this settlement, are there any provisions here that give you concern as to whether they're in the best interest of consumers or ratepayers?
We have no concerns regarding stipulations.
Okay. Let me see if there are any questions from any other commissioners. Chair Camerate, excuse me.
Thank you for being here. I just have one follow-up question from what Commissioner Messick was asking about the statutory benefits confirmation letter. And that letter, my understanding, is to confirm that the bonds or the securitization will provide quantifiable benefits to customers, and that the structuring, marketing, and pricing will be at lowest cost or reasonable cost for customers. Can you just walk the commission through the criteria or the analysis that you would be going through in being able to render such an opinion or a letter?
Certainly. We start with the structure of the bonds and trying to achieve a AAA rated security. And that's the goal of the transaction in order for the economics, the math of the financing, the cost of capital goes down as the rating goes up. So we start with, could you structure a AAA rated transaction? What are the criteria for that with the rating agencies? We can request that, but ultimately at the end of the day, they have to deliver that. So you look at what is appropriate reserve funds, flows of funds, and so forth. So we participate in that throughout the structuring period of the transaction. They do sensitivity analysis on the ratepayer base. to make sure they could withstand shocks in the system. They take a look at what the amortization period is. So there's a lot of things that go into that, and we will be involved with it, not as the primary participant, but observing, commenting, questioning, understanding why that happens. We then go into the second stage once that is pretty clear of what the rating process is going to look like, what we think the outcome should be. Obviously, it's the ratings company's decision and their sole discretion. But we start with the marketing. And the good news here is that you already know some of the investors from your previous transactions. You know who owns those securities. You know who trades those securities in the secondary market if they are trading. So we'll do some forensics on that, just to understand how that market of these securities of the 2021 transaction, how much has traded in the last several years? Has any traded recently? What is the spread in other comparable transactions out there? Or any other utility transactions that are being done? Obviously, we're working with the constraints that are given to us by both the SEC and Bloomberg about the ticker, index eligibility. It's really the index in which it's included in. But it really gets down to making sure that the widest market is addressed. So you heard from Mr. Heath that you talk about the municipal market, you talk about the mortgage asset-backed market, and you talk about the corporate market. Who are those investors? Are they likely to participate? Separate and different from other transactions.
I'm hearing from the back of the room that it's difficult to hear you.
Okay.
So if you could speak more carefully
Okay.
into the mic, closely into
Sorry.
the microphone.
I appreciate that. So we'll look at how the market is traded. I'll back up just a little bit so everybody has that benefit. We look at how the market has traded for the existing securities of the 2021, who the investors are. A lot of times you can figure out who those investors are by some of their required filings. We'll use databases of known investor holdings. We'll work with the book runner. We'll work with Duke and the companies to understand how that market's traded for those securities. What other transactions are in the market? What's the forward calendar look like for other transactions, other securities, economic data? We take a look at a lot of things. But at the end of the day, it gets down to, did you cast the widest net for investors? Did you touch all the markets that you think investors could potentially buy these securities? And there's a process for which we'll go work with the chosen book runner to go through that. We'll have our list that we've participated in as both underwriter and advisor over the years on securitizations. And we'll say, did you talk to these? Has it been approved on credit? That's the process that goes on 2 or 3 weeks prior to the actual launch of a transaction. And so once we know that, in game day, as we like to say in the industry, we want to know who those investors are. Are they participating at what is an announced spread? Can we tighten the spread based on investor demand? So what is the composition of the order book? So the underwriter has orders from, say it's $1 billion transaction. You may have $700 million worth of orders, or you may have $3 billion worth of orders. What does that order book look like? Who are they? Are they a lot of small orders or a lot of big orders? Who's the investor? How far could you push that book? And when I say push the book, can you lower the price? Or do you have to increase the price to get to an underwriting with the underwriter? Will the underwriter use their capital to essentially buy securities, a small amount of securities that haven't been subscribed for in order to complete the book? We'll just take a look at all those things. But at the end of the day, there is no clearing market like an equity, but you have to touch all these bases, and we'll triangulate on that market at that day and time with these securities, and understanding that you may have talked to 100, 200 potential investors, whatever that number is, that's addressable to this market, to make sure that it's documented what their appetite was and what their price was. Hopefully that answers the question.
It does. And one follow-up question. You mentioned that during this, I believe, 2 to 3 week process that you were talking about, that there'd be an opportunity from comment to be provided to Duke. If you have concerns, would you raise concerns during the process and before you would issue the letter? I mean, is that something that is back and forth, and any concerns that you would have, you would ask them to address upfront while the process is undergoing?
Yeah, we see this as being a constructive tension between us, the underwriters, to get what is the right price. But at the end of the day, you have to have people willing to buy the securities. And so we'll have conversations with them hey, we saw this in the secondary. Did you see that? So there's a camaraderie amongst the bond working group to help find what is the best price. Where can we establish that, and how can we establish that the steps that were taken produces the required result?
It sounds like it is something of a collaborative process.
Absolutely.
Okay.
And we talk to them sometimes 2-3 times a day during this process. Which investors have approved it? Which investors have opened the data room? How many times have they hit it? Who's approved the credit for purchase? Because the portfolio manager can buy it, but he's got to be approved by his credit team. So where are they in the process? So it's a very interactive process between us and the book runner and the company.
Okay. Thank you for the explanation.
You're welcome.
Are there any other questions from commissioners? Not seeing any. I think everybody's waived the right to cross-examine each other's witnesses, so this panel can be released. Oh, excuse me, I forgot. Question for commissioners' questions, yeah. Almost got a step ahead of myself.
No questions from the company.
SIGFR and CUCA have no questions for these witnesses. Thank you.
No questions from the public staff.
Oh, this panel can be excused.
Thank you.
Mr. Creek, are there any other witnesses?
No other witnesses from the public staff. No, sir.
All right. Well, we're getting to that. Are there any other issues that we need to address this afternoon while we are here that anyone would like to bring to my attention?
None from the companies.
None from the public staff, other than the fact that we look forward to working with the company on this important transaction.
None from CUCA or SIGFR.
And I commend you for coming up with a stipulation and settlement that everybody could buy into. And I think it was the result of good give and take and compromise. And so I commend all involved in bringing this before us for our respectful consideration. As a final matter of business, I remind the parties that pursuant to the Commission's February 17, 2025 scheduling order, post-hearing briefs and proposed orders are due no later than 15 business days from today. So that's 15 business days from today. On that note, we hereby stand adjourned. Thank you.